Tomorrow. Mention tomorrow, yes.
Supplementary list item number 1.
More than 20 years are released on bail.
Yes.
That well-being report was produced on August 24/10. There it was stated that he managed to transfer the convict was transferred to Biju Pandang Ponasram. So, since he has more than 20 years in custody, Lordship granted bail on last occasion.
See,
Well-being, but the paperwork was as reflected and not yet been prepared.
right. Manus Channel and counsel for the appellant is present. Here is the well-being report of the appellant. Stop. It is noted that paperwork has not been prepared since the criminal appeal is of the year 2005. Registry shall take immediate steps for preparation of the paperwork and copies to be handed over to the land council for the respective parties. Matter will be listed for hearing in the second week of January 2026. Next.
Item number 2.
Sole appellant dead in the meantime. Sole appellant dead in.
But ये जो रिपोर्ट ଦେଇଥିଲେ ତା ଦେହରେ କଷ୍ଟଡିରେ ଥିଲା ଲେଖା ହେଇଛି
ମାନେ ଏଟା ଆସିଛି ଏବେ 8/2025 ରେ
28/8 ରେ ଯୋଉଟା ସେଟା ପୂର୍ବରଟା 7/8
but his death took place in
6.
2006.
Okay.
Right? Then how did you submit the report on that day that he was
in custody
in 2025?
no maybe during that period in custody this period of custody has not been spelled out
last column
in custody ଲେଖିଛି କିନ୍ତୁ time ଟା କୋଉ period ଟା ସେ ଦଉନି this means he is still in custody in custody ମାନେ କଣ on the day the information has been given
that report is not.
how can it
no report is there na letter at flag RJ75 ma click karna ji that is 124 serial number
it is communicated to the honorable court.
Criminal appeal number is given 438 of 2005. ST number is there, TS case number is there, which court has convicted, it is there, and it is mentioned that in custody. And this report has been sent to us
on
7/8/2025 by the registered judicial to the Director General of so continue.
problem ଇଏ ଦେଲା ପରେ ଏଇଟା but ଏଇଟା ଗୋଟେ କାହା basis ରେ ତ କିଛି ଆସିନି ଏଇଟା ଗୋଟେ separate ଗୋଟେ କେବଳ paper ଟେ ଆସିଛି it is not a document to some letter
ନାଇଁ ସେ ସବୁ ଗୁଡାକ ଆସିଥିଲା ତ
ତାକୁ ସେ ବାହାର କରିକି ଦେଇ ଦେଇଛି
ତା ଦେହରୁ ବାହାର କରି ଦେଇ ଦେଇଛନ୍ତି ଯୋଉ ପେଜ ତା ପୂର୍ବଟେ ବି ସେମିତି ଥିଲା
but this seems to
এটাতে কোন লিখলে আপন? The inquiry was conducted in presence of the local villagers, so and so, identified as nephew of the accused and submitted written as per the statement corroborated by the local testimony. It was ascertained that Chakradhar Kaur had been he reportedly contacted so and so during the surgery and his death. As he trained to son, he was shifted to Barampur Medical College.
Then it is correct.
There is the report dated 28/8/2025 produced by the in charge inspector in charge Hojuriapura Police Station by the Land Council for the state, wherein it is mentioned that the petitioner died on 25/5/2006 during his treatment at Berhampur Medical College and Hospital. Since this report is based on field inquiry, we accept the report and accordingly and since no one has filed an application, no near relatives, that stands abated. Yes, next. 2006. Okay.
Item 3.
is allied report of
Where is the council? Suresh Chandra Mahanti, J.K. Bastia. Number contact number. Local no correct. No, number 9. The Land Council for the state has produced the report dated 11/9/2023 of IIC Narla Police Station, which shows that the appellant Sadhu Shah is alive and is staying in his village. The report is taken on record. Yes, you know or will engage somebody. Suresh Chandra Mahanti here.
I'm not talking to it.
Not clearly now since the criminal appeal is of the year 2005 and paper book has already been prepared and no one appears super legal. We engage Mr. Swan, so kahaku engage karibu kondu. If tajub dele list of problem hobe. You to regular access করছিলে তাহলে দেখি কাউকে কি বলছো তবে engage করে দেবে কাম দিয়ে দেবে next food after
Item 4.
এটা কোন হলা কোন রিপোর্ট হইলা
Alive.
চিন্ময় মাহাতি অଛନ୍ତି
Alive भाई
That we can enter.
ये alive
Yes, yeah.
paper book
Yes, Rakha is
पेपर
बुक है नहीं ऑर्डर कर दो ताकू ऐसा महांतीम को इधर
आगे,
पेपर बुक कलेक्ट करने
आगे।
Land Council for the state has produced the well-being report dated so and so of IAC so and so, which shows that the appellant is alive. None appears. Since it's a criminal appeal of the year 2005, and paperwork has not yet been prepared, the registry shall do well to expedite the preparation of the paperwork, and it shall be handed over to the Land Council for the respective parties. Land Council for the state submit that he will give intimation to Mr. Mahanti about the listing of the maps. Yes, next.
Item 5.
There are two appellant, one is dead in the death certificate is there.
One is dead.
Appellant one, अच्छा.
Two.
Who did?
Gopi Mahakur.
Mahakur is dead.
There are two appellants. Appellant 2 has died.
Vishnu Priya Mahakur is alive.
Right.
Left one. The Land Council for the state has produced the written report. Well-being report for them. Dated so and so of IAC Capital Police Station, Bhubaneswar.
No, Vishnu Priya Mahakur. Date of death 14/6. Name Vishnu Priya.
नहीं विष्णु प्रिया मर जाएगी.
Vishnu Priya dead.
So appellant 1.
That appellant number 1 is dead, and appellant number 2 is alive. Instance between 1 has filed an application form. So it updates color so far as appellant number 1 is concerned. So paperwork update है ये. What about the council? S.K. Lenka, S. Mahapatra, S.K. Sethi. जानचंद जी. Non appears for you engage कर दो ऐसा. Paper will be supplied. Matter be added to the hearing. Yes, next.
Item 6.
This case, the report was called for earlier in 2020. The main 5 years elapsed, so we may allow to take on for the face report on this case.
The 2004 year.
Press report.
Press report we may allow some time.
Though the Land Council for the state has produced the well-being report of all the appellants, but since it is of the year 2020, he seeks some more time to obtain press report. Please this matter on 16th of June, 16th of December 2025. This is taken on report. By the way, with the council, Mr. Debasis Panda and his associate. Next.
Item 7.
They connect all connection methods to lordship on 11/12/2020. Bail was granted in 57.
No well-being report of well-being premature release his last order will be passed. Whether he has been released prematurely as per the order of the so and so, or appellant has not been released on bail from the କୋଉଠୁ କାହାର ବେଲ୍ କେବେ ହେଲା କି? ଏଇଟା ଅଛି 2014 ୱେଲବିଂ ରିପୋର୍ଟଟା ନେଇ ଆସନ୍ତୁ।
ଆଜ୍ଞା
ସବୁଥିରେ ବେଲ୍ ହେଇଯାଇଛି 50 ତ ବେଲ୍ ହେଇଛି। ନେକ୍ସଟ
57 56 78
ଜଷ୍ଟ ମିନିଟ୍ ଦେଖିଲ
11/12/2014
ଫାର୍ଷ୍ଟରେ ବେଲ୍ ହେଇଛି ଠିକ ଅଛି। ସେକେଣ୍ଡରେ ତ ବେଲ୍ ହେଇନି।
ନାଇଁ ହେଇଛି 56 57 58 at a time ଆଗ ପଛ ହେଇକି
ଗୋଟେ ଜାଗାରେ ବେଲେଇଛି
କୋଉଟା
connected malware 50 JCRL 56 2010 57 10
ଆଚ୍ଛା
58
ଆଚ୍ଛା ଓ ସେଥିରେ ବେଲ୍ ହେଇଛି
57 ରେ ଆସିଛି।
3 others and
ହଁ ମାନେ ସେଇଥିରେ ଦି ଜଣଙ୍କର ବେଲ୍ ହେଇଛି ମାନେ ଇଏ
ତିନି ଜଣ।
ବେଲ୍ ହଁ ଠିକ ଅଛି ଇଏ ବେଲ୍ ଆଚ୍ଛା ତାପରେ ଆଉ ଲାଷ୍ଟ ମ୍ୟାଟରଟା 58ଟା
58 ବି ହେଇଛି
ସେଇଥିରେ ସେଇ ଅର୍ଡରରେ
ଆଗ ପଛ ହେଇକି ସେ ଅର୍ଡରଟା
58 57 ନା ଏଇ ତ ଦିଟା ଅର୍ଡର ଅଛି
ଏଥିରେ ହଉଛି
57
56 ଆଉ 57 ହେଇଛି।
ହଁ 58 କାଇଁ ହଁ 58 ହେଇଯାଇଛି
ହେଇଛି
ଠିକ ଅଛି। ତ ଆପଣ ଆଣନ୍ତୁ ସେ ଇଏ
ଆଜ୍ଞା।
ୱେଲବିଂ ରିପୋର୍ଟଟା ଏଟା ଲେଖି ଦିଅନ୍ତୁ JCRL number 50 of 2010. It appears that in this appeal, so also in the connected appeals, that is jail criminal appeal 56 57 the appellants have been directed to be released on bail. And counsel for the state seeks some time to obtain the well-being reports of all the appellants. Put up this matter. See, 16 तारीख रखो
ଆଜ୍ଞା
16 12 2025. Yes, next.
Item 8,
कंप्लेंट ऑफ दिस संदर्भ तो सारा रानी पे 11
आगु किसी ऑर्डर पास ही नहीं
रानी पे नहीं टीचर फास्ट है
last time was.
रानी पे
So
11
you obtain instruction about the complaint. Look on the this content petition has been filed for non-compliance of the order dated 22/8/2024 passed in WPC number so on so. In the operative portion of the order, it is observed as follows. You will be abstaining from to 2006 पर्यंत ये कर दो. Land counsel for the petitioner to the attention of this court to specific government in paragraph 3 of the content petition, which reads as follows. Court version response. We submitted that in spite of the steps taken by the petitioner to bring the matter to the notice of the concerned authorities, the order has not yet been complied with. Land counsel for the state seeks some time to obtain instruction. Also, 16th. ये सब से connected by the same 16/12/2025 16/12/2025 16/12/2025 okay. It's next.
item 11,
What modification?
extension of time malware as per the order passed by this honorable court on 27/11/2024 was directed to file an objection within a period of 2 weeks after receipt of which the authorities shall decide upon the issue within a period of 2 months. My lord, the objection could not be filed within a period of 2 weeks due to the old age.
No, you come to the operative part of that order. 27/11/2024. Page number 2. You are for the petitioner?
Petitioner.
Okay, you come to that operative part. Considering the some, you got it? So please.
Yes, my lord.
Got it. Page 2%.
Yes, my lord.
Last
My
line.
lord, considering the submissions made by the learned counsel for the respective parties, without expressing any opinion on the merits of the case,
Yeah.
we dispose of the writ petition with the direction that if the matter is still sub judice and compensation has not been disbursed to the persons entitled to, and any objection is filed by the petitioners within 2 weeks from today, along with the certified copy of this order, same shall be considered in accordance with law within a period of 2 months, after giving opportunity of hearing to the other parties, and the result or decision taken thereon shall be communicated to the petitioner and all concerned within 15
So
days.
now you did not file any objection.
No, ma'am.
We are not aware that whether the matter is still sub judice and the compensation had not been. That is the clause. That is the main thing which is to be ascertained. Then can only the question of extending that period of objection will arise. Suppose the matter has been disposed of or the compensation has been disbursed, who knows? So,
Compensation has yet come.
so they have to obtain instruction. Yes, sir. Yeah, who is to Mr. Nayak? You come to the order portion. এটা কি করিব আচ্ছা ইয়ে মিস্টার পাঢ়ি
Yes,
আছে
yes.
Union of India, Mr. Paঢ়ি.
Yeah.
Unmute yourself.
Yes, ma'am.
Are you having that order copy which was passed in WPC that must have been attached also this attached karna the content petition
No, my lord, the order has not.
I didn't have, my lord.
this has been filed for modification of the order either content modification of order dated 27/11/2024.
Is that I copy them, sir?
No, the order copy which was passed in that WPC.
That I didn't
27/11.
have. That I didn't have, my lord.
Have you quoted that anywhere?
Yes, my lord, I have quoted it in paragraph 2, my lord.
अच्छा paragraph 2 का सुन कौन
ଆଜ୍ଞା
पूरा पूरा तो you are not annexing them second ଜାଣିବେ file ବର୍ତ୍ତମାନ କୋଉଠି you serve a copy of that order. Are you having the copy of that order dated 27/11/2024? It must be available in the High Court website.
Yes, my lord, it is available in the High Court website.
What we pass the order, Mr. Paঢ়ি, he will
Yes,
serve during course of the day.
My lord, here, have the.
Okay. So we pass the order that we disposed of the writ petition and this is a matter where the petition was filed for a direction to the opposite parties number 2 to 4. 2 to 4 means
Mahanadi Coalfield Collector.
Mahanadi Coalfield Collector, Land Acquisition Officer, Hon'Ble Collector, so and so. Acha. Say the direction was sought for to issue fresh notice to the petitioners and other legal representatives of the recorded tenant and disburse the compensation amount for acquisition of their land under Khata number so and so one corresponding to land mentioned in the notice so and so along with the interest. So we disposed of the matter and said that if the matter is still sub judice and compensation has not been disbursed to the person entitled to, and if any objection is filed by the petitioners within 2 weeks, along with the copy of the order, same shall be considered in accordance with law within 2 months after giving opportunity, and result shall be communicated to the petitioner. So he has not filed any objection within that period of 2 weeks for which he has come for extension. But
extension may be given.
The condition precedent is that the matter must be sub judice and compensation has not been disbursed. Then,
Yes.
then can only this objection will be entertained. So we just want to know about the status of that matter. So whether it is the Union of India or the state has to obtain instruction.
State will obtain, my. State will.
ପକ୍ଷୀ ଗୋଟେ ତ ଅଛି MCL ଅଛନ୍ତି but collector and land acquisition officer, they are, I think the land acquisition officer must have the main role. Land acquisition officer on good collectorate, and of course Mahanadi Coalfield might be.
MCL can also. MCL can also. OP number 3, OP number 2.
The OP number 2 was not No notice was issued
No.
to them at that time.
Mm.
That at the initial stage it was better. You obtain the
Yeah,
inspection.
Land.
You will hand over a copy of the writ petition to you,
Yes.
along with the copy of the order and also the interim application. So whether that matter is still there or because if the matter has already been disposed of, this question of this objection doesn't arise.
Right.
That was the condition precedent that if it is pending and compensation has not been disposed of, but disbursed. But if the compensation has been, let us say, that has been finalized, he is not happy with that compensation amount. So it is in accordance with law, he will take steps.
Right.
But our order was that subject to that it is pending and compensation has not been disposed of.
Yeah.
So you take the writ petition copy, take the order copy also, which you passed, and also this interim application,
My lord.
and you obtain inspection. Let me do. The Land Council for the state let a copy of the writ petition, order dated 27/11/2004, and Mahanadi Coalfield, I think they have a separate
Panel.
panel. I think your Advocate General was appearing in one case which
Mr. Debraj Nath is the channel counsel. In some Mr. London AG appearing special.
that was the matter. But
Mr. Debraj Nath.
Natarajan was there in that matter. We delivered a judgment. So
Debraj Nath got a copy they didn't, so that he, Mr. Debraj Nath.
Asha. Let me do. Copy so and so be handed over to Franco along with the copy of the interim application. So also a copy to Mr. Devraj Mahanti, who used to appear, advocate who used to appear for opposite party number 2, and let them obtain inspection regarding as to whether about the whether the matter is still sub judice and whether the compensation has been disbursed to the person entitled to or settled. In respect of acquisition of land under Khata number 191 of Mauja Konsamunda, corresponding to the land mentioned in the notice under Annexure 5 series, the writ petition. Land Council for the petitioner shall also serve a copy of 2 days order on Mr. Mahanti, put up this matter on 16th of June. The name of Mr. Devraj Mahanti shall be mentioned in the cause list. Devraj Mahanti को जान चाहिए?
Yes, my lord.
I'll go to
I
state
have a
council.
copy on the state and serve a copy.
State को दौचंदी अपन नंबर 3 या 4 पर महानदी कोलफील्ड पर देवराज महानदी ठीक है. Yes, next.
Date.
16/12/2025. Yes.
Item 12.
Incomplete requisite ଦେଇଛନ୍ତି notice ଯାଇ ପାରିଲାନି. Find the complete requisites. Noting ଦେଖିଛନ୍ତି ତ list ରେ notice could not be issued due to incomplete requisites. The land council.
Union has already challenged the order of this honorable court.
The matter is under challenge.
Pending before honorable court.
Mr. Matthews must be known.
What do you say?
It is not audible to us. There is some glitch.
Not audible, Mr.
Lordship, I am appearing on behalf of Mr. Matthew. The order has been challenged and the SLP is pending. Lordship, kindly keep this contempt petition is pending until the SLP is disposed of in Supreme Court.
It is stated before us that the matter is challenged before the Honorable Supreme Court in SLP so number 1229 of 2025, and therefore the content petition be kept pending. List this matter after we are listing it January. January, the order copy has been produced before us, which is taken on record.
Yeah, a copy of that order they can you.
Which order? This one. Data exam of the exam. Operative part for last.
The next date is showing in Supreme Court is 15th of December, Lordship. We are not sure.
We take up it matter, madam, second week of January 2026, so that you will apprise us about the development, if any, made in the Honorable Supreme Court, right?
Right, Lordship. Second week of January.
Right. We are giving you the date of the January calendar. Where is that January calendar? We are keeping it to 8th of January 2026.
8th of January.
Yes.
Very well, Lordship. Much obliged. It's for item number 12 and 13 are same.
12
that case number is another order must have been passed, or same order?
Same order. It's the same order.
Okay.
Same order in 12, they have to take a fresh step for issuance of notice.
No, since now the matter is pending, why unnecessarily? Let it be there.
SLP number 024807, Lordship.
That and SLP number is same in both the cases?
No, SLP number are two. It's a 024807, 024808.
Order SLP number mention is okay. Put the diary number. Oh, diary number.
Special petition diary number is there.
So the diary number is there, 129 of 2025.
Yes, Lordship.
That is
but the SLP number is 024807, 024808.
Please pass it up. In both the cases, right? Item number 12 serial number 12 SLP number and item number 13 SLP number.
My Lord, I am on behalf of respond number 2, Secretary Union Public Service Commission. I have filed the counter affidavit, my Lord. In item 13, my Lord, CP 20625.
In item number item number 13, as it appears, a reply affidavit has been filed by the opposite party number 2. You are for the opposite party number 2.
My Lord, Secretary Union Public Service Commission, my Lord.
Obviously, opposite party number. That is. So have you supplied a copy of your reply affidavit to the counsel for the petitioner?
Yes, my Lord.
Madam, have you received a copy?
I'll check, Lordship, right now, so it's not with me. I'm not sure to receive.
It is stated that the copy of the reply affidavit has already been served on the land counsel for the petitioner. Stop. List this matter also on that particular day.
My name may kindly be detailed, my Lord.
That is, it is Ziaul Haq.
Ziaul Haq, my Lord.
Ziaul Haq, the land counsel is present for opposite party number 2. You are appearing only for OP number 2.
Yes, my Lord.
Okay. You give that SLP number. Yes, next.
Item 14.
Much obliged, Lordship.
Where is that, Mr. Roy? first item for phone number ଅଛି ନା
କଲ୍ କରିଥିଲି
କଣ କହିଲା
ଘର ଉଠେଇଲେନି ମେସେଜ ଛାଡିଥିଲି ସବୁ।
have you obtained that report paper ଉଠେଇ ଦିଅ food chocolate ବାଣ୍ଟୁନାହାନ୍ତି ତ ଏଇଟା କିଏ କାହା ନାଁ ରହିବ ବିଷ୍ଣୁ ନାୟକ ପିଉନ ନା
ଯେଟା latest
number one is a witness who escorted the dead body constable for postmortem examination as it appears and after the postmortem he produced the wearing apparels at the police station. Okay, number two is also the same. Number three, this one on that one Tangia was seized in front of his house and it contained blood stain. Right. Number four is the informant.
Informant and wife
And
of
he is
the
the widow of the deceased. Huh?
wife of the deceased.
Please read it out. Let him come. You just read it out.
Deceased person was my husband. I know the accused who is my son-in-law. He has married my daughter Budhivari. My husband died about 9 months back.
That daughter has been examined as PW5.
5.
Okay.
My husband died about 9 months back. At the relevant time, my daughter and son-in-law were staying separately in a house which is very near to our house. The occurrence took place on one day at about 2 p.m. At that time, my daughter was coming to our house with fish curry to serve the same to my husband. Seeing this, accused came to our house with an axe tangia and killed my husband by means of the said tangia. The accused gave a successive blow to the head and neck of my husband. Due to such blow, my husband died. My daughter Budhivari and one Lakshman Kochim had witnessed the occurrence. That Lakshman PW6.
5 and 6 are also the witnesses.
Yes, and witnessed the occurrence. After killing my husband, the accused fled away from the spot by running. While running, the accused fell down and sustained injury on his leg. The above incident took place just in front of my house. On the Krishna Madkami,
PW7.
type the affair. As per my instruction, after the affair was tried,
The contents of the affair was read over and explained to me. After know the contents of the affair to be true and correct, I put LTI. MO is the said act. My son-in-law used to assault my daughter. They were quarreling each other. Cross assumption.
Yes.
The accused at the relevant time brought the axe from our house and dealt blow to my husband.
So it is not that he had come with the axe,
Yes.
like the in the chief examination jaha कहले.
In the chief, he had spoken. No?
କହିଲା ଆଣିଲା ବୋଲି କିନ୍ତୁ ଏଠି କହିଲା ଆମରି ଘରୁ.
Came to our house with an axe, which is now verified.
At the relevant time, my husband was abusing the accused. The axe belongs to us. It is not fact that my husband tried to assault the accused. It is not fact that there was a quarrel between my husband and the accused, and that due to fall on the axe, my husband died. It is not fact that my husband assaulted the accused. As a result, he sustained injury on his legs. The accused used to quarrel with us. I had not reported at the PS about the Gondogol with the accused.
Gondogol with the accused.
Absolutely.
Now you come to the wife of the appellant.
I gave the accused married widow 5. Accused Gobindo Pujari is my husband. Widow 3, 4. Sunamani Kore is my mother. Deceased Parsuram as my father. My marriage with the accused was solemnized about 3 years back. We are staying separately adjacent to the house of my parents. After marriage, the accused, under the influence of liquor, used to assault me. He was quarreling with me. My father died about 8 to 9 months back. On the date of occurrence at about 2 p.m., I was going to my parents' house with fish curry for my father. The accused arrived there. My father asked him as to why he was quarreling with me. At this, the accused brought an axe from my father's house and dealt blow to my father on his neck and head. Due to assault, my father died instantly. After murdering my father,
MO1 identified.
After murdering my father, the accused left the spot by running. While he was running, the accused fell and sustained injury on his leg. That is examined by the doctor also, PW11. One Lakshma Kochim witnessed the occurrence at the relevant time. That is the independent PW6. My father did not tell anything to the accused prior to the above incident. He was assaulted by the accused and died instantly. I alone came to the house of my father with a fish curry for my father. My husband arrived near my father's house being unarmed. It is not a fact that my father chased the accused to assault him by means of said axe. It is not a fact that I have stated before the police that my father at the relevant time abused the occurrence. The house where we are staying was provided by my father. It is not fact that there was no dispute between us. Witness Lakshman Kachmi is a adjacent neighbor. It is not a fact that I am deposing falsely at the instance of my mother.
Next, Shaw.
I know the accused in this case. Pidol 5 Budhivari is the wife of the accused. I know the deceased Parsuram. He died about 10 months back. On the date of occurrence, I found that accused dealt a axe blow to the neck and head of the deceased. Due to assault, throat of the deceased was cut. Due to assault, the accused sustained a bleeding injury on his neck and head, and he died instantly. Out of fear, I left the spot. Being a lady, I am the adjacent neighbor of the deceased. Cross-examination. On the date of occurrence, I had been to market. I was not examined by the police in this case. At the relevant time, I was returning from the market and found the accused assaulting the deceased by giving a successive axe blow. Except the assault, I cannot say if there was any gondogol between the deceased and the accused. It is not a fact that I have stated before police that later on I came to know that there was a gondola between the deceased and accused. It is not a fact that I have not seen anything in this case and that I am disposing falsely and corrected by me. False, my lord.
Okay, now you come to the doctor's evidence, PW9, who conducted PM.
On I was asking Sergeant Sir. On that day at about 2:30 p.m. on the police location, I conducted an autopsy over the dead body of the person of the Satwankar at the Jhatimatri colony, Padamgiri, Sergeant Sir. External injury. Inside wound, 2 inch into 1 inch over left shoulder. Inside wound, 3 inch to 2 inch into 1 at the center of the neck. Inside wound, 2 inch to 2 inch into 1.5 right lateral side of the neck. Lacerated wound of the size of 4 inch 1 inch over parietal part of head.
On dissection, the larynx incised at the middle fracture of so and so larynx. The above injury is antemortem in nature, death homicidal. The injury is noticed at the time of were sufficient to cause death.
In ordinary course of nature. Cause of death was due to hemorrhage due to injury over the neck. Time since death was within about 24 to 36 hours from the time of postmortem examination. Exhibit 5 is the postmortem examination report. Exhibit 1 is my signature. On 29/11/2006, on police request, I examined the weapon of offense, that is MO1, being produced by police and submitted my report to that effect. The injury found on the body of the deceased may be caused by the said weapon of offense. The injuries were sufficient to cause death in ordinary course of nature. The broken part of the wooden handle of the axe was possible by heart stroke. Exhibit 6 is my report and Exhibit 6.1 is my signature. With the requisition issued by the police. Cross-examination. The injury which I noticed at the time of postmortem examination cannot be possible by fall on the edge portion of the tangia.
On it was suggestion that is
the other injury also cannot
be possible
due to the sudden fall. I have not examined the accused in this case. It is not a fact that the injury are possible due to the push and pull of the said weapon of the.
So 9 item you PW9 is the doctor who conducted.
In the cross-examination, we stated that all the injuries may be possible by the wooden portion of the axe by
possible, but he also fell down is not dismantled.
And the police has also stated before him in cross-examination there's a 40 and see he has stated I have examined PW5 Budhuvari Pujari who has stated before me that her father at the relevant time abused the accused.
Abused is even otherwise.
ତାପରେ ବି ଗଣ୍ଡଗୋଳ ହେଇଛି ବୋଲି ସେ PW6 କହିଛନ୍ତି.
No,
PW3 ବି କହିଛି.
ଆପଣଙ୍କର କେସ୍ କଣ ମାନେ what is your case?
Due to sudden provocation and due to he was not
no, about your injuries.
My injury that is very so happened due to some quarrel.
Come to item question number 40 in the accused statement. Page number 32. This particular question was put to you that the doctor examined you and noticed number of injuries on your person which have been opined to be simple in nature and opined further that it has been caused by falling down. Answer la jane nahi. ଆପଣଙ୍କ ଇଞ୍ଜୁରି ବିଷୟରେ ଆପଣଙ୍କୁ ପଚରା ହଉଛି ଆପଣ କହିବେ ଜାଣେ ନାହିଁ ଆଉ ଇଆଡେ କହିବେ କଣ ନା ମତେ ସିଏ ମାରଲା ସେଇଥିପାଇଁ ଇଞ୍ଜୁରି ହେଲା. Who will believe it? The purpose of accused statement, if you are taking a stand, you must be consistent that he chased me, he assaulted me, and by way of retaliation, I caused this to save myself, whatever it may be. You have taken nothing.
Court below, the London court asking the accused persons, कौन ये विषय कौन दो कही राज नहीं है वो भी जान
Are you present on that day when
ବେଳେ ବି ଏମିତି
question ପଚରାଇଛି 16-17ଟା question specifically କଣ ନା ତାକୁ ଗୋଟେ question ପଚରାଇଦେଲା ଆଉ କିଛି
ନା
ପଚାରିଲା
ନା ଆଉ ଗୋଟେ କ୍ୱେଶ୍ଚନ ପଚାରେ ମୁଁ କହୁନି କ୍ୱେଶ୍ଚନ ପଚରାଇଛି
question ପଚରାଇଛି ଉତ୍ତର ଦେଲାନି କେন
So you take it, you presume it that the court who put the question had not put the question, simply asking, what do you want to say? How can it?
ହଁ ସେଇଟା କହିଲେ
Why? We are holding courts, we don't know.
ଜାଣେ
It is being put very specifically.
you are making aspersion against a
no madam
additional session ଯଦି
that is not my fact I'm pardon for that
specifically ଇଏ କରି ସେ ଯାହା ପ୍ରତ୍ୟେକ question ର answer ମଧ୍ୟ ଅଲଗା ଅଲଗା ହେଇଛି ସେ ତାକୁ record କରୁଛନ୍ତି କୋଉଟାରେ ଜାଣେ ନାହିଁ କୋଉଟାରେ ମିଛ କେସ୍ ମୋ ବିରୁଦ୍ଧରେ ମିଛ କେସ୍ ଦେଇଛନ୍ତି ଯୋଉଟାରେ ସେ ଯାହା କହିଛି କୋଉଟାରେ ନାହିଁ ଆପଣ କହୁଛନ୍ତି ତାଙ୍କୁ ଗୋଟେ question ପଚାରିଦେଲା ଆଉ କିଛି ପଚାରିଲା
ନା ଗୋଟେ କ୍ୱେଶ୍ଚନ ନାହିଁ ତାଙ୍କୁ ପଚାରିଛନ୍ତି
no question is that when you are taking this plea that ସେ ତାକୁ ଇଏ ମାରିଲା ଯୋଉଥିପାଇଁ ଇଏ ହେଲା that is not your plea. You have neither suggested this
Witness
to the witnesses who are the eyewitnesses to the occurrence, nor even you have taken such a plea.
ମୋ ବିରୁଦ୍ଧରେ ମିଛ କେସ୍ ଦେଇଛି କିନ୍ତୁ ମିଛ କେସ୍ କଣ ସତତ ଘଟଣା ଘଟିଛି ସାକ୍ଷୀ ମାନେ ମିଛ କେସ୍ ଦେଇଛି ବୋଲି ସେ କହିଛି କିନ୍ତୁ ଇନଫ୍ୟାକ୍ଟ
No, your plea is also different. Your plea was that he fell on the X. That is also your plea. So you cannot now escape from that. You take a plea that the deceased tried to assault him. Now you say that he fell on the X. And again you say that due to the assault. No.
And the doctor, PW9, you put a specific question in the cross-examination. And he has stated that the injury which is noticed at the time of postmortem examination cannot be possible by fall on the A's portion of the tangia, paragraph number 5. And it is obvious, ବିଭିନ୍ନ part ରେ injury ହେଇଛି, inside left shoulder ରେ ହେଇଛି, neck ରେ ହେଇଛି, right side neck ରେ ହେଇଛି, parietal region ହେଇଛି, ଆଉ ତା ଉପରେ କେମିତି ପଡିଗଲେ ଏତେ ଗୁଡାକ injury ହେଇଛି?
ପଡିକି ମୁଁ କହୁନି ପଡିକି ହେଇଛି କହୁନି ଇଏ କରିଛି
ଆପଣଙ୍କର
ଦିଟା କଥା ହେଇପାରେ
ଦିଟା କଥା ନୁହେଁ what plea you have taken the question that has been your case has been put to the eyewitnesses the eyewitnesses you have stated you come to PW4 you see the suggestion what you have given first of all you see your suggestion that it is not a fact that my husband tried to assault the accused this you have not taken in your 313 statement. It is not a fact that there was a quarrel between my husband and the accused, and due to the fall on the axe, my husband died. That plea also not taken. Nor the doctor has also stated that due to fall on the axe, such injury can be caused. Third thing, it is not a fact that my husband assaulted the deceased,
So this is
as
your
a result of which he sustained injury on his leg. This you have certain injuries and the doctor treated you. The doctor was examined as PW11. Question was put to you in the 313 statement that you have sustained these injuries and the doctor has opined that due to fall such injuries can be caused. Your answer is mu jane na. Ab kiye janibo? And you see the inconsistent suggestion which have been given. ତାକୁ ଛାଡ଼ିଦେଲେ ଗୋଟେ ସଜେସନ ଦେଲେ then 5 number ସାକ୍ଷୀର ସଜେସନ ଦେଖନ୍ତୁ it's not a fact that my father chased the accused to assault him by means of said acts it is not a fact so and so I am not stated gala it is not a fact that there was no dispute gala
କିଛି ନାହିଁ
ତାକୁ କିଛି ନାହିଁ
ତାକୁ କିଛି ନାହିଁ
ତାକୁ କହିନାହାନ୍ତି ସଜେସନ ବି ଦେଇନାହାନ୍ତି ଯୋଉ ପଡିକିନି ଆକ୍ଟ ଉପରେ ହବା କଥା ତାକୁ ମଧ୍ୟ ସଜେସନ ବି ଦେଇନାହାନ୍ତି next 6 number ସାକ୍ଷୀ तार सजेशन देखंतु paragraph number 6 it is not a fact no
No, for
it is
para 5, except the assault, I cannot say if there was any gondole between the deceased and the accused. So there was neither any gondole nor abusing was there. He might have abused. That is what he got triggered, and
so as it appears from this evidence of the 3 eyewitnesses that one thing is that he was your father-in-law and the PW5 on the at the relevant point of time had come with fish curry uh, for for the deceased father, right? And you came and you perhaps quarreled you quarreled with the that your wife uh, accused arrived there. କି ଗୋଟେ କହିଛି ଯେ ତମେ ଆସିକି my daughter was coming to our house the accused she with the partner.
Govind, the petitioner, like he has assaulted the daughter of the deceased brother. Marpit kala.
My father asked him as to why he was quarreling with
ଗାଳି ଗୁଲଜ କଲା।
ତେଣୁ ଡିସିଜ ପଚାରିଲା ଯେ ତୁ କାହିଁକି ମୋ ଝିଅକୁ ଗାଳି ଗୁଲଜ କରୁଛୁ ହେଲା।
ଗୋବିନ୍ଦ
at this accused brought one axe from the father's house and dealt blows on the neck and head and he died instantaneously. So situation ଯୋଉଗୁଡା ମାନେ sequence of events ଝିଅ ଆସିଲା ମାଛ ତରକାରୀ ଧରିକିନି ବାପାକୁ ଦବା ପାଇଁ ବାପା ହଉଛି ଡିସିସ୍ଡ ଆପେଲାଣ୍ଟ ତା ପଛରେ ଆସିଲା ଆସିକିନି ତା ସ୍ତ୍ରୀକୁ ଗାଳି ଦେଲା ଏଇ ଯୋଉ ଗାଳି ଦବା ଭିତରେ ଡିସିସ୍ଡ ଇଣ୍ଟରଫିୟର କରିଛି ଯେ କାହିଁକି ମୋ ଝିଅକୁ ଗାଳି ଦଉଛୁ ତାପରେ ଇଏ ତାଙ୍କ ଘର ଭିତରକୁ ପଶିକିନି ଜ୍ୱାଇଁ ଶ୍ୱଶୁରର ଘର ଭିତରକୁ ପଶି ସେ ଟାଙ୍ଗିଆ ଆଣିକିନି ତାକୁ successive blows ଦେଇଛି on the head and neck and as a result of which he died. This is the sequence of events. ତାପରେ you ran away and the case is that you fell and fell down. That is also they have stated, PW4 has stated that the accused fled away from the spot and while running he fell down and sustained injury. This is the explanation for your injuries. And the doctor has also stated that the injuries which you have sustained can be possible by fall.
And your wife has also supported that.
Lakshman, the DW number 6, she was not present in that place.
Yeah.
DW6, Lakshman.
PW not DW.
PW 6. She was not present. Nobody has stated that
PW 4 and 5 shares that
अरे पर दी जन जापरा କହିଛନ୍ତି PW5 କହୁଛି paragraph 6 ରେ one Lakshma was witness the occurrence. FIR ରେ ତା ନାଁ ଅଛି.
How can you dispute it?
କୋଉ ବେସିସ୍ ରେ କହୁଛନ୍ତି ସେ ଜାଗାରେ ନଥିଲା.
And he himself is also giving evidence.
ଚାରି ବି କହୁଛି ଲକ୍ଷ୍ମା ଥିଲା witness the occurrence. 5 ବି କହୁଛି ଲକ୍ଷ୍ମା ଥିଲା witness the occurrence. ତା ଛଡା 6 ନିଜେ କହୁଛି ମୁଁ ଥିଲି.
He had been to market. He was returning from market when he found this incident. Para 4. I have not been examined by police. That is all right. At the relevant time, I was returning from the market and found the accused assaulting the deceased by giving successive X blows.
But like in this manner, one Giridhari Dehui, the judgment reported in 2015 60 OCR 1075. In that case, the appellant has no criminal background, and moreover, some words of the deceased must have in a fresh state the appellant who acted offensively in hust by giving a that is a single blow given.
But here it is
7 blows.
No, 4 blows. Well, in this case, due to sudden provocation and due to some disturbances in between the parties, that has been done. That has been occurred. for which the section 302 has been converted to 304 part 1 that amounted to murder under section 30 part 1 and sentence restricted to arrest for 10 years which the deceased is undergone and that undergone that period has already been taken into consideration and for which the accused was released on bail and also the judgment was reversed. And another case that 2014 supplemented to OLR 382 Miller, Buddhimanta Naik. In that case, Miller, that 302 that has been also report for
ବହି ଦିଅ ସେ ଯୋଉ ଦଉଛନ୍ତି Come to paragraph number 7. अच्छी ये
judgment
ଦିଟା କରିଦେଇ ପଳେଇଲେ ନିଜ ପାଇଁ ରଖିଲେନି
A blow.
ବୁଦ୍ଧିମନ୍ତରେ but it appears there are successive blows that all and 4th, 5th line and give successive blows 50 line individual
ପଡିଗଲା ପରେ ସେଠି ସେଠି hospitalized he succumbed to the injuries in violent treatment. He was taken to hospital. So out of the 3 injuries, 2 injuries were simple and 1 was grievous. But in this case, all are fatal. What is the report? Cumulatively. Particular 9 कौन कर ले? Cumulatively. Injuries which I noticed at the time of postmortem examination were sufficient to cause death in ordinary course of nature. Cause of death was due to hemorrhage, due to injuries over the neck. Yes. Here it is, the person had been to the hospital, he was undergoing treatment and he succumbed to the injuries. So there was chance of survival. Here death is instantaneous.
But that petitioner.
No, here the death is instantaneous. So instantaneous death means intention is apparent.
There is no intention, but due to some
intention is apparent, premeditation is not there. In this case, there was no intention because he was shifted to hospital. There was no question of instantaneous death in the decision that you have suffered. Anyway, they have given 10 years.
Another judgment is there on to Prabhakara Bhatal conflict. In that case, injuries of head, it proved fatal, and knowledge of such effect that the injuries can be questioned against the appellant. Apart from the disease, the essence of intention.
But here, this is part 1.
The motive behind the commission of the crime is absent. My lord, the past judgment, whether the appellant has already been acquitted, my lord. Yet the judgment it has been reported. And 614 one while one.
You are going inside the house, bringing a sharp-cutting weapon, assaulting, dealing 4 blows on the head
and neck.
neck. So what was your motive?
Motive to not to kill Miller, but
Huh?
to
He died instantaneously, and you say that there was no motive.
ଶରୀରରେ ଏଇ ପୋର୍ସନ ଟାକୁ ଛାଡିଦେଲେ ଆଉ ବହୁତ ଜାଗା ଥିଲା।
ଗୋଡକୁ ମାରିଛି, ହାତକୁ ମାରିଛି, ଭାଇଟାଲ ପାର୍ଟ ଇଜ ନେକ୍।
4ଟା ବ୍ଲୋ ଦେଇଛନ୍ତି, 4ଟା ଯାକ ଏଠି ତଣ୍ଟି କଟି ଯାଇଛି, ଲ୍ୟାରିଙ୍ଗ୍ସ କଟିଛି ପୁରା। ତେଣୁ ଆଗରୁ ୟୁ କ୍ୟାନ୍ ସେ ପ୍ରିଭିୟସ୍ ମଧ୍ୟ ତାଙ୍କ ଭିତରେ ମାନେ ସମ୍ପର୍କ ଠିକ ନଥିଲା, but that is why they were staying separately. ये ताकू quarrel କରୁଥିଲା ତା ସ୍ତ୍ରୀ ସାଙ୍ଗରେ, that is there. On the date of occurrence, this thing happened all on a sudden, and it may be that the husband was not willing that the fish curry should be given to the father-in-law, and maybe that wife has brought it, and he might not be knowing also, the husband. So when he came to know and came there and quarreled with the wife, this man interfered.
Or could be anything. He might have asked his wife not to serve fish, and by the time he saw that his wife is going, he chased and found that yes, she is going to the father's house. So he got triggered and
ମଦ ପିଇକି ତା ସ୍ତ୍ରୀ ସହିତ ଗଣ୍ଡଗୋଳ କରିବ ବୋଲି କି
ସେଟା ତ ଅଛି ଏଭିଡେନ୍ସ।
ସେ ଯୋଉ ଗଣ୍ଡଗୋଳ
ଆରେ ଗଣ୍ଡଗୋଳ କରୁଥିଲା ଯେ ବାପା ମା ଯେହେତୁ ପାଖରେ ରହୁଥିଲେ, ସେଟାକୁ ମନା କରିବେନି ଝିଅକୁ ତମେ, so that is natural. So that cannot be the cause for which he would have been so I mean taken it so gravely. He came on the very day, at the very moment, just to chasing his wife, dissuading her not to give, probably. Because the moment he abused his wife, father interfered and he got triggered. He had not come to kill. He had come there to see his wife, not to serve. To protest.
ଦେଖ
when he give her test mirror, that is the straight. The culpable homicide not amount to murder. Section 304 part 1. That is.
ଦେଲେ ପରା
ନା ଗିରଧାର ଦେଉର ଦେଇନି।
ଏଟା ଗୋଟେ ଦିଣ୍ଡି କଣ ବୁଦ୍ଧିମନ୍ତ ଦେଇଛନ୍ତି।
ବୁଦ୍ଧିମନ୍ତ ଦେଇଛି।
ଏଇ ଦିଟା ନା ଅଡିସନ, ଏଇ ଦିଟା ତ ବସନ୍ତ
ଆଉ ଯୋଉ ଡିସିସନଟା ଅଛି
ପ୍ରଭାକର
ଭାଇଟାଲ ପ୍ରୋସେସ
the JCRL number 95 of 2007, Govinda Pujari Appellant.
Words of the cases must have integrated the applicant by a single blow, but it can be
The appellant faced trial in the court of and additional session is Malkangiri in criminal trial number 29 of 2007 for offense punishable under section 302 of the Indian Penal Code. The accusation that on 27/12/2006 at about 2 p.m. at village Jhatti Mati Colony, Padmogiri, he committed murder of Parsuram Pura, bracketary here after the deceased, intentionally. The Lennon trial court by judgment and order dated 31st October 2007 found the appellant guilty of the offense charged and sentenced him to undergo imprisonment for life. The prosecution case, as per the first information report lodged by PW4 Sunamani Pura, the widow of the deceased, on 27/12/2006 before the officer in charge of Malkanagiri police station. In short, is that on that day, no, 3 years prior to the date of occurrence, our younger daughter, Udhuvari, bracket to PW5, married to the appellant, which was a love marriage. Stop. 6 months after the marriage, both the appellant as well as PW5 came to the house of the deceased and stayed there in a separate mess. The appellant frequently used to assault PW5. And the deceased used to oppose the appellant in that respect. On the date of occurrence, that is on 27/12/2006 at about 2 p.m., the deceased was taking food, sitting on the veranda of the house. PW5 came there with fish curry for the deceased. The appellant came there and assaulted PW5. Stop. The deceased abused the appellant over this issue, and the appellant all on a sudden brought one tangia from the house of the deceased and assaulted him. It is further stated in the first information report that the informant herself, or daughter Budhuvari bracket PW5, and the co-villager Lachama Kuchim bracket PW6, and another Jamuna Suna were present at the scene of occurrence. and witnessed the same. While the appellant, after assaulting the deceased, was running away from the place and trying to jump over the fence, he received some injuries. Stop. On the basis of the oral information given by PW4, PW7, Krishna Madkami scribed the written report, and it was presented before the officer in charge of Malkangiri police station, who registered Malkangiri PS case number 177 dated 27/12/2006 under section 302 of the Indian Penal Code against the appellant. After registration of the case, the officer in charge directed PW10 Prakash Kumar Rothwam, the SI of police attached to Malkangiri police station, to investigate the case. Stop. PW10, the IO, the investigation of the case, examined the informant and other witnesses, visited the spot, prepared the spot map, held inquest over the dead body, prepared inquest report exhibit 4. He also sent the dead body of the deceased to district headquarters hospital, Malkangiri, for postmortem examination, and seized sample earth and Gloucester earth on the same day as per seizure list exhibit 9. He also seized the weapon of offense from the spot under seizure list exhibit 2. Weapon of offense calculation, that is Tangi abracadabra MO1. On 29/12/2006, he arrested the appellant in the village, seized the wearing apparels of the appellant and prepared seizure list exhibit 10. Stopped. On the same day, he also seized the wearing apparels of the deceased at the police station, which were produced by the constable after post-mortem examination. The appellant was sent to district headquarters hospital, Malkangiri, for medical examination. Stop. The IO also sent the weapon of offense to the medical officer for examination, and he seized a sample blood, sample saliva, nail clippings, command certificate as per seizure list exhibit 12. He received the opinion of the doctor to the query met and forwarded the appellant to court on 29/12/2006. On 14/3/2007, he sent the exhibits to the RFSL Berhampur through SDGM Malkangiri. And on completion of investigation, on 19/3/2007, he submitted charge sheet against the appellant under section 302 of the Indian Penal Code. Next part, after submission of charge sheet, the case was committed to the Court of Sessions following due procedure where the London trial court framed charge as aforesaid. The appellant pleaded not guilty, claimed to be trial upon the sessions trial procedure was resorted to establish his guilt. Stop. In order to prove its case, the prosecution examined 11 witnesses collectively. The prosecution also proved 13 documents collectively. I also proved one material object, that is MO1 of the Cambia. The defense plea of the appellant is one of denial, and it is stated that a false case has been foisted against him. The London trial court, after analyzing the oral as well as the documentary evidence on record, came to hold that from the medical evidence adduced by PW9 and the injuries sustained by the deceased as per the post-mortem report finding, it can be said that the deceased died a homicidal death. The London trial court accepted the evidence of three eyewitnesses, that is PW4, PW5, and PW6, and came to hold that the story narrated in the FIR, Exhibit 3, gets ample corroboration from the oral evidence of PWs 4 and 5, and from their evidence, the prosecution has successfully proved the motive on the part of the appellant to commit the crime. The London trial court further held that the evidence of the doctor PW11 to prove the injury report of the appellant revealed that the prosecution has successfully proved and explained the circumstances under which the appellant sustained injuries on his person. It is further held that the direct testimony of PWs 4, 5, and 6 is also consistent with the medical evidence. It was further held that in view of such direct evidence available on record coupled with the medical evidence, it can be said that the prosecution has proved the charge under section 302 of IPC against the appellant beyond all reasonable doubt. Mr. Dilip Roy, Appellant Counsel, appearing for the appellant, argued that there was no motive on the part of the appellant to assault the deceased, and the prosecution has not explained the injuries sustained by the appellant, and it appears that from the evidence on record that the occurrence happened all on a sudden, and the appellant had not come to the spot with intention to commit any crime, and he was not armed with any weapon. And it appears that a sudden quarrel ensued between the deceased and the appellant when the appellant opposed the conduct of his wife, bracketed PW5, in serving fish curry to her father, bracketed deceased. And even though the appellant brought the axe from the house of the deceased and dealt some blows, but since it was under grave and sudden provocation, it cannot be said that the offense under section 302 IPC is made out. And in absence of premeditation, in the factual scenario, it may at best be a case under section 304 part 1 of IPC, even if the direct evidence of the witnesses like PW456 as well as the doctor, bracketed PW9, conducted post-mortem examination is accepted. He has placed reliance in the case of Budhimanto Nayak versus State of Orissa, reported in 2014, supplementary to Goela 382, and Joga alias Jagabandhu Mahali versus State of Orissa, reported in 2024, 1 ILR 1047. এই দুইটা ডিসকাউন্ট দেই না আচ্ছা এই বইরে দুইটা and Prabhakar Vittal Golve versus State of Maharashtra, reported in 2016, bracket ভিতরে bracket বাইরে 64 OCR SC 449, And Sudhakar versus State of Maharashtra, reported in 2012, bracket with 53, Orissa Criminal Reports SC 114. The Learning Council further argued that the appellant was taken into judicial custody on 29/12/2006 and he was not granted bail during pendency of the trial. However, after he preferred this jail criminal appeal, he was granted bail by this court on 28/9/2012. And since the occurrence in question took place in the year 2006 and almost 19 years have passed in the meantime, even if this court held the appellant guilty under section 304 part 1 of the IPC, altering the conviction from 302 IPC, the sentence be reduced to period already on the stop. Mr. Jateshwar Naik, an additional government advocate, on the other hand, supported the impugned judgment and submitted that the evidence of 3 eyewitnesses, that is PW 4, 5, and 6, have not been second in the cross-examination, and their version get corroboration from the evidence, medical evidence adduced by PW9, and the weapon of offense, that is MO1, was produced before the doctor who examined the same and who find that the injuries found on the body of the deceased might be caused by such weapon. The Land Council submits that even though some suggestions have been given to the witnesses that on account of fall on the arcs, the deceased sustained injury, but when a specific question was put to the medical officer PW9 in the cross-examination, he has denied that the injuries found on the person of the deceased could be possible by fall on the edge portion of the tanglia. The Land Council submits that the doctor, bracketed PW11, has noticed some simple injuries on the person of the appellant and opined the same to be simple in nature, and further stated that such injuries can might be caused by falling down while running, and the witnesses to the occurrence have stated that while the deceased fled away from the spot, while the appellant fled away from the spot running, he fell down and sustained injuries
while scaling the fence.
While scanning the fence. Therefore, the injuries sustained by the appellant has been explained by the prosecution, and the plea which has been suggested to the witnesses regarding the sustained by the deceased is also not consistent, and such plea has also not been taken by the appellant in his accused statement. Therefore, no importance can be given to such suggestions which has been given, And since the appellant brought the axe from the house of the deceased and assaulted him by using sharp side of the weapon, and as many as 4 blows were given to him uh, on the vital part of the body like head and neck. Therefore, it can be said that by causing such injuries, the appellant intended cause the death of the deceased, and therefore the London Trial Court has rightly found him guilty under Section 302 of the Indian Penal Code. Stop. Adverting to the contention raised by the London Council for the respective parties, let us first examine the evidence on record as to how far the prosecution has successfully established that the deceased has died a homicidal death. Apart from the inquest report, the evidence of the doctor PW9 is very much material, and he has stated that on 28/12/2006 he was posted at as an assistant surgeon DHS Malkangiri, and on police requisition he conducted autopsy over the dead body and noticed the following external injury and the internal injury and opined like this that, and we also examined the axe which was sent by the investigating officer MO1 and opined that the injuries found on the body of the deceased might be caused by the said weapon of offense, and further opined that the injuries were sufficient in ordinary course of nature to cause death. As rightly pointed out by the London Council for the state, though one suggestion was given to the eyewitnesses that on account of fall on the tangia, the deceased sustained injuries, but the doctor has specifically denied the same when in cross-examination, the London Defense Council has put the questions, suggested to the doctor that the injuries caused, sustained by the deceased would be possible on account of fall on the edge portion of the tangia. Stop. In view of such medical evidence, we are of the view that the London Trial Court has rightly come to the conclusion that the death of the deceased was homicidal in nature. In fact, Mr. Roy, the Land Counsel for the appellant, has not disputed the homicidal death of the deceased. Stop. Now, coming to the direct evidence available on record relating to the assault on the deceased, the evidence of PW4, PW5, and PW6 are very relevant. PW4 is none else than the informant of the case, who is also the widow of the deceased. And she has stated that the appellant was her son-in-law and the who married to her daughter, Uduwari PW5. She stated that both the appellant and PW5 were staying separately in a house which is very nearer to their house, and the occurrence took place at about 2 p.m. And at that time, PW5 was coming to her house with fish curry to serve the same to the deceased. And on seeing this, the appellant came to the her house with an axe bracketed tangia and killed the deceased by means of the tangia by giving successive blows on the head and neck, for which the deceased died. She further stated that PW5 and PW6 uh, Lachama Kochim witnessed the occurrence. She further stated that after killing the deceased, the appellant fled away from the spot by running, and while running, the appellant fell down and sustained injuries on his legs. The witness has also identified the axe bracketry MO1 to be the weapon of offense. And he has stated that the appellant used to assault PW5 and they were quarreling with each other. In the cross-examination, however, the PW4 has stated that the appellant at the relevant point of time brought the axe from their house and dealt blows to the deceased, and that at the relevant time the deceased was abusing the appellant and that the axe belonged to the deceased. Stop. Suggestions have been given to PW4 that the deceased tried to assault the appellant and there was a quarrel between the appellant and the deceased, and due to fall on the axe, the deceased died, and that the deceased assaulted the appellant, as a result of which he sustained injury on his legs. But PW4 denied such suggestions. In fact, the suggestions which has been given to PW4 as well as to the other two eyewitnesses are completely different, and no such plea has been taken by the appellant in his statement recorded under section 313 CRPC. This specific suggestion given to PW4 that on account of fall on the axe, the deceased died was also put to the doctor who conducted post-mortem examination, and the doctor specifically denied that the injuries noticed at the time of post-mortem examination could not be possible by fall on the edge portion of tangia. The evidence of PW4 has thus remained unchallenged, and except the contradiction that in the chief examination he stated that the accused brought the axe with him while coming to the spot, and in the cross-examination he stated that the accused appellant brought the axe from the house of the deceased. There is no other material to disbelieve the evidence of PW4. PW5 Budubari Pujari was the daughter of the deceased, who is also the wife of the appellant. And she has stated that her marriage with the appellant was solemnized about 3 years back, and they were staying separately adjacent to the house of her parents. And after marriage, the appellant, under the influence of liquor, used to assault her and was quarreling with her. She further stated that on the date of occurrence at about 2 p.m., she was going to her parents' house with fish curry for her father deceased. And the appellant arrived there, and when the deceased asked the appellant as to why he was quarreling with PW5, the appellant brought one axe from the house of the deceased and dealt blows to the deceased on his neck and head, and due to the assault, the deceased died instantaneously. He further stated that after committing the murder of the deceased, the appellant left the spot by running, and while running, the appellant fell down and sustained some injuries on the legs. She specifically stated that PW6 witnessed the occurrence at the relevant time. In the cross-examination, she has stated that she alone came to the house of her parents with fish curry, and her husband, appellant, arrived at the father's place being unarmed. Those suggestions have been given that the deceased chased the appellant to assault by means of an axe, but the witness PW5 has denied such suggestion. Stop. Nothing has been brought out in the cross-examination of PW5 to disbelieve the same. Though the contention was raised that they are related witnesses and likely to speak falsehood, but law is well settled that mere relationship with the deceased cannot be a ground to doubt the testimony of the witnesses. On the other hand, the related witnesses are not likely to spare the real culprit and implicate innocent persons. The contention that was raised that PW6 evidence as eyewitness cannot be accepted on the however, as his presence is doubtful, we are not inclined to accept such submission in as much as not only in the first information report, but also in the evidence of PW4 and PW5, there is specific mention that at the time of occurrence, PW6 who was the neighbor, their neighbor was present. Stop. PW6 has specifically stated that he had seen the appellant as a she had seen the appellant dealing axe blows on the neck and head of the deceased, and due to the assault, the throat of the deceased was cut, and the deceased sustained bleeding injury and died instantaneously. In the cross-examination, she has stated that at the relevant time she was returning from the market and found the appellant assaulting the deceased by dealing successive axe blows. She further stated that except the assault, she couldn't say if there was any disturbance between the appellant and the deceased. Nothing has been brought out in the cross-examination of PW6 to disbelieve the evidence. Therefore, if we analyze the evidence of these three eyewitnesses, we find that their evidence is consistent, that it was the appellant dealt successive blows by means of axe M1 on the deceased on his head and neck, as a result of which the death of the deceased has taken place instantaneously. They have also stated that PW 4 and 5 have also stated that after the assault, the appellant was running away and he held down and sustained injuries, and the PW 11 has examined the appellant on police requisition and noticed some bruises and abrasions on his person, and specifically stated that the injuries were simple in nature and might have been caused by falling down while running. In view of the available material on record, it can be said that it was on account of assault of the deceased, on account of assault of the appellant, the death of the deceased has taken place. Now coming to the submission raised by the London Council for the appellant, that in the factual scenario, it cannot be said that the case falls under within the ambit of section 302, and it appears it may be a case under section 30 part 1 of the Indian Penal Code. We find force in such argument. It appears that the occurrence happened all on a sudden, and it was the afternoon time when when PW 5 had come with the fish curry to serve his deceased father, and the appellant came and quarreled with the PW 5 over this issue. And at that time, the deceased interfered and asked the appellant as to why he was quarreling with PW 5. This might have triggered the situation, and the appellant, who had not come to the spot with any weapon, suddenly brought out one axe from the house of the deceased and dealt some blows, of course, on the neck and head, and then ran away from the spot. The absence of any premeditation is lacking in the case. In the case of Buddhimanto Nayak, bracket Supra, on which reliance has been placed by the London Council for the appellant, it is held as follows, quote paragraph number 7 in its entirety. In the case of Joga alias Jagabandhu Mohali, এটা কোন এটা সাইন দিয়েছিল, এটা সেটা সে দিয়েছি, এটা ফুড সাইন দিয়েছিল, হ্যাঁ
ଇଧାରି ଦେଉରିଟା ଦେଇଥିଲ ନା
ଏଇଟା
ଏଇଟା ବି ଯାଉ ସେଟା
କିଛି ନାହିଁ, କାଟି ଦିଅନ୍ତୁ।
ସେଥିରେ ଅଛି in absence of any intention. Towards last
but here your case is not to that.
Next ଦେଖନ୍ତୁ, in the case of ସେଟା କାଟିଦେବା, in the case of Prabhakar Vitthal Golbe, it has been held as follows, for paragraph number 6 and 7 both. In the case of Sudhakar versus State of Maharashtra, It is held as follows, quote paragraph number 9. In the case of Surinder Kumar versus Union Territory Chandigarh, reported in AIR 1989 Supreme Court 1094. It has been held that to invoke exception 4 to section 300, 4 requirements must be satisfied, namely, it was a sudden fight. Roman 2, there was no premeditation. Roman 3, the act was done in a heat of passion. 4, the assailant had not taken any undue advantage or acted in a cruel manner. The cause of quarrel is not relevant, nor it is relevant who offered the provocation or started the assault. The number of wounds caused during the occurrence is not a decisive factor. But what is important is that the occurrence must have been sudden and unpremeditated, and the offender must have acted in a fit of anger. Of course, the offender must not have taken undue advantage or acted in a cruel manner. In the said case, though number of injuries were caused to the deceased and on the vital part of the body, the Honorable Supreme Court, taking into account the factual scenario and the provocation part, has altered the conviction from 1 under section 302 to section 304, part 1 of the Indian Penal Code. In the factual scenario, we are of the view that since in the case in hand, it appears that the deceased and the appellant were related to each other as father-in-law and son-in-law, and there was no premeditation on the part of the appellant to assault the deceased on that particular day, and the occurrence happened all on a sudden when PW5 came with fish curry to serve her father, bracketed deceased, and the appellant opposed to the same, opposed to his wife, bracketed PW5, and the deceased interfered and quarreled with the appellant, which might have been the cause for provocation, and it seems that the appellant acted in a fit of anger and dealt blows by bringing the axe from the house of the deceased and left the place. In such a situation, we are of the view that the case of the the exception one for the I think it is grievance submission is exception to section 300 of the Indian Penal Code is squarely applicable in this case, and the case comes under culpable homicide not amounting to murder, but in the factual scenario, since it can be said that there was intention because of the part of the body selected to assault the deceased.
So also the weapon.
Huh?
So also the weapon.
So also the weapon. Therefore, the case comes under section 300, part 1 of the Indian Penal Code. Accordingly, the conviction is altered from section 302 to section 304, part 1 IPC. sentence to follow. This is meant for 5%. James is that the apparent as not followed on these levels and in some 7 years. Time level, coming from huge probability. And you market movie. So say possibly that's why you market movie stars of the even comment. Now, I told you if these are I don't know you to play on.
I have no contact with him.
Se police buझियोनी
Police
All right, yeah, these are like corporate capital.
पैसा रे मिलने जा से सेटा ऑर्डर का कम्युनिकेट हो जाता है सेटा ऑर्डर में को रन करो
हाँ जोटा होटेल काम कर रहुची मिलिटारी म्युनिसिपालिटी
की कम आया होगा वो तो दे दो दे दे सब दे दे खाएंगे दे दे उधर से
IAC Martin dated 3/12/2024 that the afterend was working as a driver and now he's working in April near Martin Boston and staying in Wisconsin as well stop center for Morgan service and also parents died and his and his wife also died 2 years back and his only daughter Deepti Pujari married and the petitioner the appellant has to work more criminal antecedent either prior to the commission of this crime due to the date of offense or after being released from the bracket with permission. The report statement of it that's it. That's all.